Yusuf Patel's case was sent to the court and it was answered. This is just...
The question was sent here. Where does it say?
My lord, this is the... If you
originally referred were.
Yes, my lord.
And then what happened later? They said...
This is the judgment, my lord, where that question is then answered. And the Supreme Court...
Where is the question?
The question is, my
questions
lord,
originally referred were
page
suggested as
449, if your lordship may see.
These are the two.
Question number 2. If your lordship will see just before the indentation.
Yes, so there were 4 questions.
Originally referred were 1 and 2, subsequently 3 and 4 were also suggested, but your lordship will find a direct reference to an earlier judgment of the court in question number 2.
Did they say they can do so? Where?
Yes, my lord. That is the entire thrust of this long opinion, and they say they can do that.
Under 186, whatever. What was the equivalent of 186 there?
Yes. And the question is answered. And the same has happened.
So, can we see the equivalent provision? Now,
yes,
can we go to your chart?
Yes,
Should we go to your chart?
My lord, the equivalent provision is there in the chart as Article 213 of the Government of India Act 1935.
Is it parameteria the same?
My lord, in a way it is not exactly the same language. If at any time it appears to the Governor General that a question, this is the last column, is that a question of law has arisen or is likely to arise which is of such a nature and of such public importance that it is expedient to obtain the opinion of the federal court upon it, he may in his discretion refer the question to that court for consideration, and the court may, after such hearing as they think fit, report to the Governor General thereof.
Makhdoom, is the question that was Yusuf Patel correctly decided or collaterally addressing Yusuf Patel?
My lord, if Yusuf Patel was correctly decided, then the government of the day was...
No, but the question is not whether Yusuf Patel is correctly decided.
No. And the question over there, my lord, is that in view of Yusuf Patel's judgment, if it is strictly followed, what is to be done? And the court then provides a way out.
Which does not upset Yusuf Patel.
My lord, Yusuf Patel remains as the law, but if your lordship sees the reasoning, in spite of the fact that all those laws which have been struck down by Yusuf Patel are allowed to remain in operation, which were essential till such time that a new constituent assembly comes in and provides a legal framework for the country.
लेकिन इस पे तो ये हुआ कि वो कहा कि यूसुफ पटेल the interpretation is correct.
Yes.
After that, how the government can run?
My lord.
Yes. How the government will run?
My lord,
उसको तो benchmark बनाया ना कि that is the interpretation by the final interpretation by the court.
Correct.
After that, so that is an opinion sought by
the court that in view of the decision in Yusuf Patel.
What was the decision? Explain, Karlin, because Yusuf Patel is not under question.
No. Yusuf, neither
that is one big distinction is this.
The consequences of Yusuf Patel were.
Because, my lord, if Yusuf Patel if Yusuf Patel was good law, if Yusuf Patel was fully given effect to by all the executive authorities of the country as they are required to, then the problem would be that the government of the day could not function. And therefore, they were virtually indirectly seeking from the Supreme Court a way out to continue to function in spite of Yusuf Patel.
And in Yusuf Patel, there was a review filed or not? Or what was the...
My lord, I am not aware, but it shows that whatever was the situation...
Was Yusuf Patel's case passed in review, or was it just appeal?
Yusuf Patel was it's a criminal appeal, and that's the final decision. And if there was a review, it's not on the record, at least as reported in PLD.
Interesting thing, same 5-member bench.
Yes.
Yes. So it wasn't even a larger bench, it was the same bench. Actually, we are a larger bench.
Yes.
So,
and my lord, before your lordship, to my mind, the shorter question, the question of constitutional law is that if later or subsequent events disclose to your lordship that the judgment may have been infected or there was a reasonable apprehension of bias or reasonable suspicion of bias, can that judgment continue to be declared as good
So
law.
the question actually really could be, I don't know if that's possible,